The broadcast is now starting. All attendees are in listen-only mode.
Hi, everyone. Welcome to today's webinar, Legal Issues in Colorectal Cancer. Thank you for joining us today. My name is Sharon Worrell, and I'm part of the Fight Colorectal Cancer team. Joined today by Reese Garcia, also of the team who's helping manage some of the webinar. Today, we're super excited to have Monica Bryant joining us from Triage Cancer. We will have a Q&A at the end of the session, so if you have a question, please go ahead and type that in the panel on the right side of your screen, and we'll get to those at the end. And of course, as always, we do record the webinars, and they can be found in our webinar archive on FightCRC's website at fightcrc.org. And finally, if you have Twitter, feel free to tweet along. We will be tweeting throughout the session some of the great information that will be shared today. Fight Colorectal Cancer has a host of excellent patient education resources, including our Tabooty podcast, a variety of mini magazines talking about specific topic areas, and Your Guide in the Fight, which is our 3-part guide for those diagnosed with colorectal cancer. The information and services provided by Fight Colorectal Cancer are for general informational purposes only. The information and services are not intended to be substitutes for professional medical advice, diagnoses, or treatment. If you are ill or suspect that you are ill, please see a doctor immediately, and in an emergency, call 911 or visit the nearest emergency room. Fight CRC never recommends or endorses any specific physicians, products, or treatments for any condition. And finally, we're super excited to welcome Monica, who is a cancer rights attorney, speaker, and author. She's been doing this work for a long time and is just super knowledgeable on all things related to law, finances, cancer, etc. She is the COO of Triage Cancer, and if you haven't visited their website, you should. There's lots of great resources there. And yeah, so Monica, thank you for joining us. I will go ahead and hand over the controls to you.
Well, thank you so much for that lovely introduction. Often people in the cancer community, when I'm introduced and called up, are confused as to why an attorney is going to be speaking with them. But the reality is that so many of the issues that patients, survivors, and caregivers are forced to deal with after a diagnosis are rooted in the law. And having an understanding of the law, their rights, and how to navigate those options can significantly improve somebody's circumstances. Of course, this is a totally broad topic, and we only have an hour today, so I'm really going to focus in on 2 of the most common topics, which are health insurance and employment issues. But know that at my organization, Triage Cancer, we have many resources to deal with the other practical and legal issues that can arise. So given that, I'm just going to spend a few moments telling you about Triage Cancer so that after today's webinar, in addition to Fight CRC's amazing resources, you also have another place to go that if you have questions about other topics or want more information about what we talk about today, you have somewhere to go. So for those of you who aren't familiar with Triage Cancer, we are a national nonprofit organization that provides education on the legal and practical issues that may impact individuals diagnosed with cancer and their caregivers. And we do this education in a couple of different ways. We host a speakers bureau of experts, so if organizations or institutions are putting on an educational event, they can reach out to us and we'll connect them with the most appropriate speaker. We also participate in events all over the country. Some of these are posted by our wonderful partners like Fight CRC, and some are events that we host ourselves. So to see where we're going to be in any given point in time, you can check out our events calendar. We host 3 Triage Cancer conferences every single year. It's a day-long event that covers a variety of survivorship topics, and we welcome patients, survivors, caregivers, advocates, healthcare professionals. Really, everybody is welcome, and you can see where we're going to be this coming year. We also host some webinars. We have one coming up on January 23rd, where we will be doing a deeper dive into employment issues. You can also see all the recordings of our past webinars as well on our website. And then in addition to our events, we offer a number of educational materials and resources online. Our quick guides are designed to be a snapshot of a particular topic. They cover areas like health insurance, employment, clinical trials, finances, estate planning, so much more. All of these documents can be downloaded for free on our website, or you can order hard copies by visiting our website as well, and I've given you the link here as well. And you will see throughout today's presentation, we have provided the links to various quick guides based on where I am in the presentation. So if you want more information or if you want a hard copy reminder in addition to the slides, check out those quick guides. Now, we know that everybody learns in different ways, so we created an animated video series on various survivorship topics. This one happens to be about health insurance basics. And we are adding videos on a regular basis. They're available in English and Spanish, and the English videos also have Tagalog subtitles. We also have a comprehensive list of some of the most state-specific resources, and you'll see in today's presentation why it matters what's going on in your state. Excuse me. And because where you live can impact what protections you have access to, we have charts of state laws on employment, disability, health insurance, and other cancer-related legal issues. And then finally, we have a supplementary website called Cancer Finances that provides practical information on topics that impact your finances. And the website's designed where it poses several questions, and then based on the user's answers to those questions, it will guide them to the most relevant information to their situation. So we have modules on health insurance, disability insurance, education rights, and financial assistance resources. And again, we're adding more on a regular basis. And then finally, our educational blog. Excuse me, I'm fighting a little bit of a cold, so bear with me. We have an educational blog that provides great information about various cancer survivorship topics. And because things are constantly changing in the cancer community, this is where we share our late-breaking news. So without further ado, let's get to the heart of the topic today. If you've ever tried putting together one of those giant jigsaw puzzles at some point, you could imagine how challenging it might be to complete that puzzle if you've never seen what the final product is supposed to look like. And that's really how it can feel to a lot of people who are navigating this complex maze of cancer. They're diagnosed, they find out along the way that there's so many things they need to think about, to deal with, but they don't always really have a sense of what that overall big picture is going to look like. So through the various programs that we try to provide, we give individuals the various pieces so they can put together their own unique puzzle. And when I'm talking about the puzzle pieces, these are what I mean. So we're talking about the specifics of your employer's policies, federal and state laws, employment contracts, how does finances and insurance coverage come into play? And all of these pieces are critical because it's in the cases where people don't know what the law is or what they're entitled to that they can ultimately fall through the cracks. Generally, there is a lack of understanding about health insurance in this country. To back up that assertion, we have some data based on a survey conducted of individuals who get their health insurance from their employer. And they were asked questions about their employer policies. And the results were striking. Less than a quarter of the individuals understood the terms that were being used in their health policy. Only half of them could tell you what they were paying to have their health insurance, and only about half of them could figure out what their bill was going to be. So it really goes to show that something as basic as having an understanding of the terms used in a health insurance policy can make a significant impact. So before I get into some of the specifics about what's happening with health insurance right now, I just want to make sure that we're all on the same page with respect to some terminology. These are terms that are used often, but are frequently misunderstood. So when we're talking about a premium, we're talking about the amount that you're going to pay monthly just to have health insurance. And you're going to pay this whether you go to the doctor or not. It's very similar to paying for car insurance all year long and never getting into a car accident and needing to use the insurance. Then there are some costs that you're going to incur when you actually use your health insurance. First is your deductible. And your deductible is the amount that you have to pay before your health insurance company will cover their share of the costs for your medical care. And it's going to be a fixed dollar amount, and it's going to depend on your policy. So some policies have a $0 deductible. Some policies have a $10,000 deductible. It's just going to depend. Next is your co-insurance or your cost share. Two different terms for exactly the same thing. And this is the amount that you're responsible for paying after the insurance company pays their portion of the bill. So if you have a plan that has a 20% co-insurance amount, that means your health insurance is going to pay 80% of the costs of your care, and you're going to pay 20% of the costs once you've met that deductible. Another very common charge is a copayment. And this is an amount, a fixed dollar amount that you're going to pay when you get care. Again, it's going to depend on your policy what this dollar amount is going to be. But for example, some policies will have a $25 copayment when you go see the doctor, or a $10 copayment when you pick up your prescription drugs. And you have to pay that out of pocket before they let you in the door to see the doctor. Now, the out-of-pocket maximum is perhaps one of the most valuable things for people to understand about their policies. Generally speaking, the out-of-pocket maximum is going to be everything you pay out of pocket towards your deductible, your co-payments, and your co-insurance. So it's everything that you pay out of pocket except that monthly premium. Now, of course, like with everything else, the devil's in the details. So typically health insurance policies will only count payments made towards in-network services towards your out-of-pocket maximum. And then we've also seen some plans carve out the deductible or even carve out co-payments. So it's critical to look at your specific policy. But here's why understanding how your policy works and what your out-of-pocket maximum is so valuable. Meet David. David has a plan with a $2,000 deductible. His co-insurance is 20%, and he has an out-of-pocket maximum of $4,000. David has a $102,000 hospital bill. What does he have to pay? So first, he has to pay his $2,000 deductible, which leaves $100,000 left of the bill. His co-insurance is 20%, which 20% of $100,000 is $20,000. But thankfully, David has a plan with a $4,000 out-of-pocket maximum. So he will only have to pay $2,000 of that $20,000 bill till he reaches his out-of-pocket maximum. So he's paid $2,000 for his deductible, and then another $2,000 to reach the out-of-pocket maximum. Now, I recognize this is a very simplistic example of how this works, and it can get much more complicated in real life. But if people understand how this works, they can be very strategic about some decisions around their healthcare. So in 2010, a law that you may have heard of called the Affordable Care Act, otherwise known as Obamacare or healthcare reform, all various names for exactly the same thing, was passed. Now, the Affordable Care Act, or the ACA, is a huge law, and we have many, many resources that talk about all the various protections that it's afforded the cancer community. So today I really want to focus on some rather late-breaking news and to let you know what's going on with all of this. The ACA made some major changes in how insurance companies can decide who they're going to sell policies to and how much they're going to sell them for. So the first thing the ACA did was it said that insurance companies can only look at 4 things when they're going to decide how much they're going to charge somebody. This is also known as premium rating. So they can only look at, is somebody buying an individual policy or a family policy? If they're buying a family plan, it's obviously going to be more expensive. They can look at their geographic location, and it's based on zip code. They can look at their age. So yes, the more older you get, the more expensive it will be, but there is a cap on how much more expensive it can be. And tobacco use. If you use tobacco in most states, you can be charged more. Now you'll see some states have eliminated that provision, but generally speaking, that is the 4 things that they can look at. So it takes pre-existing conditions, health status, and gender out of the equation when they're deciding how much they're going to charge people. Now, the ACA also said that insurance companies can no longer deny selling somebody a policy or providing coverage for medical care because of a pre-existing condition. I'm sure I don't have to tell you that this is game-changing for individuals in the cancer community. But there are a couple of things that I want to note about this. During the election and the efforts to repeal the Affordable Care Act, many elected officials stated things like, no, we like the pre-existing condition protections and we want to keep those protections. But really what they were talking about was the second part, not the first. And the problem with that is that it doesn't really help a cancer survivor to simply have the right to buy a policy if insurance companies can charge astronomical amounts for that policy. So in my opinion, to truly be meaningful to the cancer community, these 2 provisions have to stay coupled. Now, in the last few months, we've seen some rather, interesting things happening. For example, last January, Idaho made the announcement that they will allow insurers to sell policies that don't comply with the ACA. And of course, all of these decisions have some bigger impacts that we have to talk about. There have been other moves to expand what's referred to as short-term health insurance policies. So these plans generally have a much lower monthly premium, and so they look very, very attractive to individuals. But we want people in the cancer community to be aware that these plans are not required to provide the consumer protections that are included in the Affordable Care Act. And they're able to deny selling to individuals with pre-existing conditions, and they're allowed to exclude treatments for pre-existing conditions like cancer. So they could sell somebody with cancer a policy, but say, we're not going to cover chemotherapy, for example. Additionally, most of these plans have a really high out-of-pocket costs for very minimal coverage. So again, they look very affordable because the premiums are so low, but they end up costing individuals more in the long run when they go to use it. Furthermore, these plans are not considered to be what's called creditable coverage, since they're not required to renew coverage. So if this plan ends in the middle of the year, then it doesn't trigger a special enrollment period to buy a marketplace plan, which typically leaves somebody uninsured until the beginning of the next year. And that could happen in the middle of cancer treatment. So the reality is that these plans were supposed to be eventually eliminated under the Affordable Care Act because of these pitfalls, but instead we're seeing them grow. And late last year, we got a final rule from Health and Human Services, or HHS, that allow people to buy short-term health insurance plans for up to 364 days. So the plan will last 1 day short of being required to comply with all the ACA's protections. So again, these short-term plans might be an okay option for some people, but we really just want individuals, especially individuals in the cancer community, to be aware of the potential pitfalls. Now, another thing that the ACA did as an attempt to stabilize the health insurance market and incentivize purchasing health insurance was imposing a requirement to purchase health insurance or pay a penalty. So that meant that if someone chose not to have health insurance, And these are all the various types of health insurance that count. So if you have something through your employer or you purchase an individual plan, Medicare, Medicaid, veterans, COBRA, all of those things are health insurance. If you have those, you're good. If you don't have those and don't fall into one of the exceptions, you would have to pay a penalty. Now, last year, Congress reduced the penalty to $0 starting this year. So the penalty still technically exists, it's just been reduced to $0. As a result of that change, the Texas Attorney General led a group of 17 Republican states attorneys generals and 2 governors and 2 individual gentlemen. They filed a case in Texas saying that now that the individual mandate had been reduced to 0, the entire Affordable Care Act should be considered unconstitutional. Last summer, the U.S. Department of Justice, which is the federal agency that is charged with defending federal laws in court, said that they're not going to defend the Affordable Care Act, which is a pretty significant break from the executive branch's tradition of upholding existing law. The next day, California Attorney General, along with 16 other states attorneys general, said, no, we would like to come in and defend the ACA in court. So we're seeing some very interesting things happening legally. Now, last month in December, the day before open enrollment was to end, the judge in this case ruled that the entire Affordable Care Act is unconstitutional. So what does this actually mean for us? At the moment, not a lot, because people who have picked plans for 2019 will have their insurance for 2019. And all of the other protections included in the Affordable Care Act will continue while this case goes through the courts. If this case eventually ends up at the Supreme Court, and the Supreme Court decides that the ACA is unconstitutional, it would mean that a minimum of 20 million Americans would lose their health insurance coverage. And those with employer-sponsored health insurance could face pre-existing condition exclusion periods once again. So we bring this up because it's happening at the moment, and we want people to be aware of it. But we also don't want people to be scared by what they're hearing in the news if it's not the full story. So we actually did a blog on this last month, and I've given you the direct link here if you want to read more about the details. And as developments occur, we will be keeping the cancer community updated in our blog as well. So stay tuned for that. Now, I did mention the marketplaces. So one of the things that the ACA did was create health insurance marketplaces, which are really best explained by comparing them to health insurance shopping malls or Amazon for health insurance. The plans being sold in the marketplaces are through private insurance companies, Aetna, Humana, Blue Cross Blue Shield. Those are the types of companies that are selling policies. But there are some additional benefits to buying plans in the marketplaces. There's some quality control in that all of the plans have to meet certain standards. For example, as of this year, they cannot have an out-of-pocket maximum of more than $7,900 for an individual. Now, I am not suggesting that $7,900 is an insignificant amount of money at all. But when we think back to the David example of his $102,000 hospital bill, you can see how these out-of-pocket maximums can greatly reduce how much somebody has to pay if they have significant medical expenses. Now, another thing that the marketplace did was try to simplify the shopping process for consumers by grouping plan options into categories based on their cost share amount. So for example, bronze plans have a cost share of 60-40. Silver is 70-30, gold is 80-20, platinum is 90-10. Now, bronze plans will typically have the lowest monthly premiums and the highest out-of-pocket maximums. Conversely, platinum plans are going to have more expensive monthly premiums, but may have lower out-of-pocket maximums. So consumers can now sort and shop for health insurance much like we do for other consumer items like appliances or clothing. Now, Medicaid applications are accepted year-round. Open enrollment for this year for most states ended December 15th. But I bring this up because, as you can see, certain states decided to expand their open enrollment period much later. So if you're in DC or California or Massachusetts or Minnesota, you still have time to purchase a health insurance policy for this year. Medicare open enrollment ended December 7th, and employer plans really vary employer to employer, but many of them happen in the fall. So what happens if somebody has a life-changing event that doesn't occur during open enrollment? The good news is that the Affordable Care Act created a special enrollment period for individuals who are losing their minimum essential coverage. So for example, if you switch jobs, or you've aged out of your parents' policy, or you've moved states, all of these things will trigger a special enrollment period where you have 60 days to enroll in a marketplace plan. So now, if somebody were to lose their employer-sponsored health insurance, let's say, for example, they get diagnosed and they need to stop working to deal with their treatment and recovery, they actually have more options than ever before. They could elect COBRA or state COBRA to extend their coverage. They could purchase a plan in their state's marketplace through a special enrollment period. Maybe they're eligible for another group plan, like going on a spouse's plan or a parent's plan if they're under the age of 26. Or maybe Medicare or Medicaid if they're eligible for those. Now, the trick with this is that individuals have to pick a lane and stay in it until their next open enrollment period. If anyone has any questions about this, we have a video on how to pick a plan. And if anyone is ever concerned about what they should be doing if they're losing their employer-sponsored coverage, they can feel free to reach out to us. Now, one of the most effective things that people can do to mitigate the financial impact or burden of a cancer diagnosis is to have the right health insurance plan. But how do you actually go about picking a plan when you have more than one option? Buying health insurance is one of these things that we are never taught how to do, and yet we become adults and we are just expected to understand how we shop for this health insurance policy. So I'm going to quickly go through an analysis, and I'm going to use the marketplace as an example. But this analysis works whether you're comparing two marketplace plans, whether you're trying to decide between two different plans your employer is offering you, whether you're maybe deciding, do I take my employer plan, or do I say no thank you to my employer plan and buy a plan in the marketplace? Or even if you're on Medicare and you're trying to decide between a Medicare plan. The same analysis that I'm about to go through applies. So here we have an example of someone who's eligible for 3 different policies. Excuse me. The first is a bronze policy with a monthly premium of $173 and an out-of-pocket maximum of $6,000. The next plan is a silver plan with a $271 monthly premium and a $5,200 out-of-pocket maximum. And then finally, we have the platinum plan, which is almost $400 a month and a $1,150 out-of-pocket maximum. Many people will look at these 3 options and assume that the bronze plan with the $173 monthly premium is in fact going to be the most affordable. The problem is that in order to truly know what a plan is going to cost somebody, you have to do the math. Now, this analysis is most appropriate for someone who is expecting to hit their out-of-pocket maximum for the year. And because we generally are speaking to the cancer community, that's almost always a given. So assuming that somebody's going to hit their out-of-pocket maximum, this is how we do the math to figure out which is going to be the most affordable plan. You take that monthly premium, you multiply it by 12 to get the annual amount, and then you add the out-of-pocket maximum. And when you do that math, you can see here that in fact, that platinum plan ends up being almost $2,000 cheaper at the end of the year than the other two options. So as consumers, we often get sticker shock by that $400 a month monthly premium, but we really want people to do the math to see how is it going to impact them throughout the year. But looking at that total annual cost is only half the battle, or the first step. Some plans may have a higher deductible, which means that you have to pay a lot of money up front before your plan starts to pick up their share of the cost. So some plans may have a $7,000 deductible, which means that you have to come up with $7,000 out of pocket before your plan starts picking up their percentage. Whereas if you maybe pick a plan with a more expensive monthly premium but has a very low deductible, it ends up spreading out the amount that you have to pay throughout the year rather than coming up with that one big lump sum. Now, after somebody's looked at the cost of the plan, they then need to make sure their doctors and other healthcare providers are in the plan's network. Many plans won't cover medical care that you receive from an out-of-network provider. So even if you pick the most affordable plan, if none of your doctors are in that plan's network, it's essentially a useless plan to you. And finally, you want to check what prescription drugs are covered and at what rates. Again, we just released, or it's a couple months old now, an animated video on how to pick a plan. It's about 7 minutes long and it goes through all of this again. So if you want to hear it again for yourself, if you want to share it with your friends and family, if there's healthcare providers that want to share it with their patients, please feel free. Because again, we're never taught how to make these decisions, and picking the right plan can have such a huge impact. Now, I mentioned it can be useful to look at the plan's network and the prescription drug coverage. And the marketplaces actually give us some new tools to do that we didn't have necessarily before. So you can check to see if your doctors are in the network. Now, I do recommend doing due diligence because it's not always 100% accurate what's on the website. So it's always best to check with your providers as well as checking the website. And then as a reminder, we have a website called Cancer Finances that have some additional financial assistance resources. If you're having trouble paying for other costs, it may be useful to check out what's there as well. So switching gears slightly, I want to talk about the second largest contributor to the financial burden or financial toxicity after a cancer diagnosis, which is employment changes. We often hear stories of healthcare providers telling patients, well, you're going to have to stop working through treatment. Or patients just assuming, I've been diagnosed with cancer, how can I work? But that may not actually be the reality for everybody. And in fact, there are several laws that might provide protections for individuals in the employment arena. And there are a number of places where we can go to find information about our employment rights. There are fair employment laws, both federal and state. There are leave laws, both federal and state. And if you're an employee working under a contract, then you may have some additional rights or options. For example, if you're a member of a union, then you should be sure to look at your union contract for any additional or specific employee benefits. But as we talk about rights and benefits, it's really valuable to remember that the state and federal laws that we are going to talk about are the bare minimum of what employers must provide to their employees. But there are tons of employers out there that provide benefits that are much greater than those bare minimums. So always a good idea to look at your employer's policies and and I'm really generalizing here, typically these can be found in some sort of document like an employee manual or some other types of policy and procedures documents. I fully recognize that not all employees have something as formal, but if you don't have access to that, then maybe asking a coworker, a human resources representative, or whomever in your workplace deals with things like pensions and health insurance and payroll, they might be able to give you some information. And some of the things that might be helpful to look for are things like insurance options, disability insurance, and other types of benefits. For example, does your employer already have a policy in place that allows for telecommuting or some type of flex time? Does your employer allow other employees to donate their paid time off to a pool of time that you might be able to draw from if you need it? And the reason that we want people to understand and know what their employers are offering them is because how can you access these benefits if you don't even know they exist? Now, a good employee manual may also lay out a process for how you can ask for some type of medical leave or ask for a reasonable accommodation. So it can be a really great source of information to avoid individuals from having to reinvent the wheel, so to speak. The first federal law that I want to talk about is the Americans with Disabilities Act. And this is a law that prohibits discrimination against people with disabilities in several contexts, including in the workplace. Now, many people who are diagnosed with cancer don't really consider themselves to have a disability, and therefore don't really assume that they're protected under the ADA. But this is one of those situations where I really urge people not to get caught up in the labels because they may end up missing out on some protections. Now, like with all the laws that we talk about, not everybody is going to be eligible for protections under the ADA. There are a few hurdles that a patient will have to jump. First, somebody has to work for a private employer with 15 or more employees or for a state or local government. Now, if they're a federal employee, they're probably going to be covered under the Rehabilitation Act of 1973. It's the precursor to the ADA. It's very similar, but it's important to know which law you're actually covered under. Now, in addition to working for a large enough employer, the second hurdle is individuals have to be qualified. Legally, that means that the person can perform the essential functions of the job with or without a reasonable accommodation. Practically, what that means is that if you're qualified for the job in question and can perform the essential job responsibilities, but you can get help to do that through an accommodation. And we'll come back to accommodations in just a minute. Now, the final hurdle is that you have to have a disability within the ADA's definition of disability. And over the course of the hour, you're going to hear me use disability a couple more times, but it's important to remember that every law we talk about has a different definition. So under the ADA, a disability is a physical or mental impairment that substantially limits a major life activity. I realize there's a couple parts to that, so let's break it down. The first is that you have a physical or mental impairment, and that physical or mental impairment limits a major life activity, and that limitation is substantial. So what's a major life activity? It's going to be anything that the average person in the general population can perform with little or no difficulty. So we're talking about things like sleeping, walking, breathing, eating, communicating, concentrating. All of these things are major life activities. And when we're talking about cancer, oftentimes it's not the cancer itself that creates the disability, but rather it's the side effects from treatment that somebody's experiencing, like nausea, hemobrain, fatigue, anxiety. And it could be one of those side effects is substantial by itself, or it could be that it's a combination of those things that create the presence of a disability under the ADA. So once we've determined that somebody is in fact protected under the ADA because they've cleared those three hurdles, there's 4 ways to actually use the ADA's protections. First, if somebody currently has the physical or mental impairment that substantially limits a major life activity. So maybe they're going through treatment and suffering from extreme nausea that makes getting through the workday impossible. The second is that they have a history of having that impairment. So they're a 10-year survivor with no current symptoms and may not be in active treatment, but their employer's treating them differently because of their diagnosis. The third way is being regarded as having a disability. And this really isn't about your experience or capacity at all, but rather about your employer's perception of you. And that employer is perceiving you as having a disability, even though you're not substantially limited in any way. So for example, maybe because of treatment, you have lost all of your hair, but other than that, you're doing well and you want to go to work. But because of that bald head, your employer is now treating you differently. And feel free to insert any sort of side effects that you like in that example. The fourth way that you can be protected is based on having an association with a person with a disability. And this is where caregivers may be protected from discrimination under the ADA. Now, the ADA applies to all phases of the employment process, which means it doesn't just provide protections when you're an employee, but it also provides protections when you're a job applicant. So even before you get the job, if you're qualified, you may be protected under the ADA. So what does the ADA actually do for you? In all of these circumstances, so you currently have a disability, you have a history of having a disability, you're being regarded as having a disability, or you're a caregiver, the ADA protects you against discrimination in the workplace. So you cannot be treated differently because of your medical condition. Now, if you currently have a disability or have a history of having a disability, in addition to being protected against discrimination, you're also entitled to something called a reasonable accommodation. Now, a reasonable accommodation is any change in the work environment or in the way that things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. It's a mouthful, I know. The best way for me to explain reasonable accommodations is through some examples, and these examples can really be put into three different categories. So the first is about physical space. It could be about moving offices because your office happens to be next to the communal kitchen and Bob likes to microwave his tuna fish sandwich every day at lunch and that makes you nauseous. It could be about being closer to the restroom or access to an elevator, a closer parking spot. Excuse me. Anything that has to do with one's physical workspace. The second category is about schedule. It could be about telecommuting. So if somebody has a ridiculous commute and it's adding 4 hours to somebody's workday, maybe they can work from home or from an office location that's much closer to their home. Maybe it's about moving to go part-time. Or maybe it's about just shifting schedule. So if you have a job that doesn't require you to be working specific hours, maybe you can work earlier in the day. So instead of 9 to 5, you'd work from 7 to 3. Or maybe you work 3 hours in the morning and 5 hours in the evening, depending on your work situation. It could be about additional breaks. So maybe your job currently allows you to have 2 15-minute breaks and a 45-minute lunch. Well, maybe you can take 3 15-minute breaks and a 30-minute lunch. It's really all going to depend on what you're experiencing and your job to figure out what types of reasonable accommodations might work best. Now, the final category is sort of everything else. Maybe it's about using technology. So it could be about Skyping into meetings instead of having to travel to a different city for them. It could be about using a smartphone and recording meetings so that you don't have that anxiety of, am I going to remember everything that's said, and can just participate in the meeting. It could be about a change in policy. So if you have to wear a uniform and that uniform doesn't provide enough coverage for an ostomy bag, maybe you can wear a different item of clothing to cover the ostomy bag. It could be about, excuse me, having access to different benefits. Another example of a reasonable accommodation is a shift in responsibilities. So remember, to be a qualified individual, you just have to perform the essential functions of the job. So if there are non-essential things, maybe those can be shifted to other employees. And then finally, it might be about changing jobs altogether. And this accommodation only works if there is a vacant position available. So employers aren't required to create a new job for you as a reasonable accommodation. Now, when considering reasonable accommodations, it can feel a little bit like you're asking for a favor. So we want individuals to know that this is their right under the law, and that employers who fall under the ADA are required to provide you with a reasonable accommodation unless they can show it's an undue hardship or a direct threat, which is a very, very high bar to meet. But when you're thinking through reasonable accommodations, just remember that they have to be reasonable. So in most situations, if somebody's a school bus driver, they probably aren't going to be able to telecommute. And it may be that you need more than one accommodation to deal with all of the things that you're coping with. And remember, when I talked about the ADA, I said that caregivers aren't legally entitled to reasonable accommodations, but it can't hurt to ask. Many of those employers are much more generous than what the law requires, and employers often want to retain valuable employees. Now, reasonable accommodations are perhaps one of the most valuable tools for individuals who are trying to work through treatment or who are returning to work and are still dealing with some side effects. So we have many, many resources on reasonable accommodations, and we've given 2 quick guide links for you here as examples. Now, when you're asking for accommodations, it brings up another number of questions about how you ask. Generally, we think you should ask for an accommodation as soon as you realize you need one, because you don't want your job performance to suffer and then have employers make decisions based on that job performance suffering, not knowing that you need the accommodation. You don't have to invoke the ADA or say the word reasonable accommodation when you're asking. Employers should really understand what you're asking for. But you may have to be in the position of educating your employers, and the Job Accommodation Network, I've given you the link here, is a wonderful resource for that as well. Now, it's also valuable to recognize that needs change over time. What you might need in the middle of active treatment may be different than what you need 6 months out or a year out or 5 years out. And reasonable accommodations are not something that it's like you've gotten year 1 and you exhausted that. You can get different accommodations as things move forward. Now, as I've mentioned earlier, excuse me, there are some state laws that are also very similar to the ADA, but some state laws are in fact more protective. And one of the ways that state laws can be more protective is by covering smaller employers. So this chart shows the number of employees that each state requires an employer to have to be covered by the state and fair employment law. So for example, if you live in Illinois, then your employer only needs to have 1 employee to be protected. Now, if you don't see your state listed on this chart, then it's the same as the ADA, and it covers employers with 15 or more employees. Now, whether an employee is the one who's been diagnosed or you're caring for one, you may need to take some time off for treatment and recovery. And that's where the Family and Medical Leave Act, or the FMLA, comes into play. The FMLA allows eligible employees to take time off to deal with your own serious medical condition or to take care of a seriously ill child, parent, or spouse. There are, of course, eligibility requirements for the FMLA. Your employer has to have at least 50 employees, or if you work for any government, you'd be covered. As an employee, you also have to work long enough. So that means a total of 12 months in the last 7 years. And in the last 12 months, you have to have worked at least 1,250 hours. Now, there's often a lot of confusion about the FMLA and why it's so important. The FMLA entitles eligible employees to up to 12 weeks of unpaid leave per year to deal with your own serious medical condition or to act as a caregiver. And while the leave is unpaid, and that's certainly a downside to it, it is incredibly valuable because FMLA puts you in a protective bubble. The 12 weeks of leave is job protected and health insurance protected, which means that you cannot be fired while you're out on FMLA leave. And your employer has to continue paying their portion of your health insurance if they did so prior to you taking leave. Now, the FMLA can be used in a 12-week block, or it can be used intermittently. So, for example, if you just need every Friday off for treatment, or you need a day off here or there when you're not feeling well, the value of making sure that leave is designated as FMLA leave is that it puts you in that protective bubble. Now, again, there are lots of details here that we don't have time to get into, but we have multiple quick guides on the FMLA and several different webinars on using the FMLA and how to pay for that unpaid leave. So feel free to check those out. Now, just like with fair employment laws, there are state leave laws as well. Some are more protective in that they cover smaller employers. Some are more protective in that they have an expanded definition of family. So that's valuable as well to check out your state leave law. Now, I very quickly want to talk about disclosure because it's one of the most common questions we get. And we want people to be empowered to know that they don't necessarily have to tell their employer about their cancer diagnosis. But they may have to disclose some information if they're trying to use the ADA's discrimination protections, if they're asking for a reasonable accommodation, or if they're asking for medical leave. And again, we have a quick guide on this topic as well. And the reason we want people to know is we want them to be empowered, that they have some choices around disclosure and what they share, and that there can be some long-term impact about sharing. So your current employer might be incredibly supportive, but you may not work for that employer forever. And certainly there are some impacts outside of the employment arena as well. And while employers are entitled to a medical certification to certify that you're eligible for these rights, they don't necessarily get to know the exact diagnosis, and that if somebody is concerned about sharing, there are some strategies to be honest with your employer, but then also maintain your privacy. So for example, maybe not going to your oncologist to have them fill out the medical certification form, but rather going to a primary care physician or a social worker. So again, we have tons of resources on our website for more information, both on employment and health insurance. And with the time left, I'm happy to take questions as they come in.
Thank you so much, Monica. What a great presentation. A lot of useful information. I'm over here taking notes. Very informative. Just as a reminder to folks that are tuning in, if you have questions, go ahead and type them in on the right-hand side of your screen. And I'll go ahead and get started. So we have a question here. Does every health insurance have an out-of-pocket maximum, or do some not have that?
So it might be possible for you to have a plan that doesn't have an out-of-pocket maximum. For example, some of those short-term plans might not have one. If you are buying a plan through the marketplace, it will have an out-of-pocket maximum, and it cannot be more than $7,900 for an individual for this year. That is the most it can be this year.
And then that changes yearly?
It does change yearly. It does change yearly. And this year we saw the highest jump compared with last year. So we really don't know what it's going to be next year, but at least you can go in knowing there is that cap.
Okay. Our next question. I read that cancer patients are twice as likely to declare bankruptcy. How can I avoid this?
So there are some staggering statistics about bankruptcy for individuals with a cancer diagnosis. And there are many ways to help mitigate that, what we refer to as that toxicity, that financial toxicity. And in fact, on the Triage Cancer website, we have a checklist to mitigate financial toxicity, and it shows you or poses several different questions around all areas of your life and provides some resources on how to deal with those. But I would say briefly, the most important thing you could do is have an adequate health insurance policy. To go through those steps I talked about, make sure your providers are in network and that you've really done the math. And then the second piece is to do your best to put all of these puzzle pieces together and access the benefits you are eligible for. So for example, if you have access to disability insurance, to use that. If you can continue to work, to use that. But again, that checklist to mitigate financial toxicity is on our quick guide page on our website, and it might point you in the right direction.
Awesome, thank you. And we can find that link also and share that on our website and through Twitter as well, so people can find it easily.
Yes.
So back to the insurance company question previously, we have a follow-up question. Can the insurance company charge out-of-pocket maximum for both in and out-of-network medical bills?
Yes. So some policies may have a separate out-of-pocket maximum, one for your in-network providers and one for your out-of-network providers. Some policies may also have a separate out-of-pocket maximum for your prescription drugs. So it's not necessarily to say that's a bad thing. It's just about understanding the policy that you're purchasing so that, again, you can maximize the policy you have.
Great, thank you. I think we have just time for maybe one or two more. We hear about the Medicare loophole for colonoscopy screening. What can a patient do to find out if they're covered or not if a polyp is found ahead of time?
So under the Affordable Care Act, that loophole has been closed for private policies, but you are correct that Medicare has not addressed that. In previous Congresses, there have been bills introduced to try to close that for Medicare. We've obviously just started a new Congress, so I don't think it's been introduced yet, but it will likely be introduced again. And I would say there's two things that I suggest you do. One, it's talk to your provider themselves to see how they would bill it. And then the second thing is contact your elected officials. It's so important for your elected officials to know how these policy loopholes that may seem so small to them can really impact real life people and their constituents. And if you are looking for information about how to talk to your elected officials and how to be an advocate, we have several resources on our advocacy page. And I know Fight CRC does quite a bit of advocacy work as well, too.
Thank you. And I know we're at time, but if you don't mind, just one more question.
Yeah.
Let's see. So in terms of clinical trials, what do you know about insurance coverage with costs associated with clinical trials? Is it the same across the board, or what recommendations do you have for patients that are curious to know what will be covered if they join a clinical trial?
So under the Affordable Care Act, private insurance companies are now required to cover the routine costs associated with care, even if somebody's in a clinical trial. So for anything that would have been covered if you weren't in a clinical trial, insurance companies are still responsible for that. But then anything above and beyond that, which is typically what the trial is testing, has to be covered elsewhere. And I'm generalizing here, obviously, but generally that's going to be covered by the trial itself. The challenge for some people is they don't always realize that when they're participating in a clinical trial, there may be other costs associated. So for example, if now you have to go to your healthcare facility twice as much, that doubles the parking costs, that doubles the time off work. So there are some additional cost factors that people need to take into consideration. But certainly clinical trials are so incredibly important in the cancer community because we wouldn't have any of the advancements that we have now without them. We do have some resources on clinical trials on our website about how to find them and how to pay for them, if that's helpful. But again, it can be really useful to talk with the providers, with the clinical trial them itself, to understand how they're going to bill things. And then also to contact your insurance company to find out if you need special prior authorizations and if they're going to cover care that's maybe out of network. So unfortunately, it's a lot of work put back on you as the patient and the caregivers. But if this work is done prior to incurring the expenses, oftentimes it can help keep the expenses down.
Great, thank you. All right, well, I think that wraps it up. Thank you to everyone joining live. Again, we have been recording the session. It will be posted to the Fight CRC website by tomorrow. And Monica, thank you so much for sharing your expertise. It was wonderful to have you today.
Thank you so much for having me.
Thanks, everyone. Bye.